Jason Silverglate from Dedicated Now. My question is, how enforceable are evergreen clauses in the contract?
Evergreen clauses are just as enforceable as any other clause in your contract. There's significant law that stands for the proposition that evergreen clauses and early termination provisions are enforceable according to your contract. In fact, I have at least 2 cases pending where we are going to enforce my client's evergreen clauses in the customer's failure to provide adequate notice prior to terminating the contract.
Right. Hillary Stiff from Cheval Capital. My question is on acquisitions. If the buyer can assume credit card information from the seller, specifically in Canada, we're running into that frequently.
Whether or not you can transfer credit card information is going to depend on 3 things. The first thing is what your contract with the customer says. So you need to make sure that the customer's contract is assignable and that you think that information within that contract is in fact assignable. That analysis really depends on your privacy policy or the target company's privacy policy. Can personal information that is collected pursuant to the privacy policy be assigned or transferred? And third, whether or not the law of the country allows that to happen. So in the U.S., that's generally not a problem since that's based on contract law, but you can't really assign credit card information for entities from the European Union or European Union nationals.
My name is Malik Khan, based out of Raleigh, North Carolina with Point Click Technologies. And the question that I asked most for legal is some clients that want you to do everything for them they'll provide you the information, and then we go to our website and sign them up for the customer. So if something was to come up and then we did the sign up and then accepted the agreement for them, how does that work if something came up and they wanted to sue us or bring up some sort of litigation against us?
Click wrap agreements and shrink wrap agreements and other similar agreements are absolutely enforceable according to their terms. You shouldn't have any problem legally enforcing a shrink wrap or a click wrap agreement, regardless of whether or not you require your customer to click I accept or something of that nature. I generally recommend that clients ask their customers to click I accept, not for any other reason other than it removes one barrier to the arguments that customers often make that contracts aren't enforceable. But if you have an online agreement, they are almost always as enforceable as general paper agreements.
I'm Amarjyoti from Bobcats, and my question is, can a U.S. or Canadian company host private websites from Italy?
Generally speaking, Canadian and U.S. companies, particularly U.S. companies, cannot host Iranian websites. I can't really speak to Canadian law, but in the U.S., Iran and 4 other countries are on the denied parties list, and so you cannot do business with them. So if you are hosting Iranian websites and you're from the U.S., you are actually violating U.S. law.
Hi, my name is Sangeeta. I'm from WHIR, and I had this question asked recently to me by an Iranian web host, and he wanted to know if it's possible for a U.S. company to sell software to an Iranian company.
Just like you can't sell web hosting to Iranians or the Iranian government, you also can't sell software or services to Iran. So you can't ship software to Iran, and also you can't give Iranian nationals access to your software, even if the software is in the U.S.